Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning and welcome. This is our weekend review, our analysis, our discussion of the most important stories in law, in government, and the aspiration for justice in America. Thank you so much for spending some portion of your Saturday morning with me and my wonderful producer, Kelvin. We are here in the studios of WAUK Radio in downtown Waukesha. It's the Shaw, 540 AM, 101 FM. This broadcast, other broadcasts of civic media here in Waukesha, southeastern Wisconsin, and throughout the state of Wisconsin. Delighted once again to have you with me and with Calvin here this morning on Saturday, February 11th, 2023. My name is Jim Santel, and today, as always, we have an ambitious but nonetheless achievable and informative, hopefully also inspiring program for you this morning, covering lots and lots of territory, including some special features this morning, some special notes about things coming up this hour, next hour, and then in the broadcasts ahead into the month of March as well. Stay tuned for all of that as well. This morning, as we always do, we're going to be asking questions about what happened. What are the basic facts of the stories that we're talking about? Why is it important? Why should I care? Why should we be concerned about these stories in our American life and our livelihood? And then what should we do about those things? If there is something to engage in, what is that activity? What is that next action that we should be taking? What happened? Why is it important? And what should we do about it? Thank you once again for joining me this morning in our discussion of those stories of law, government, and justice in these United States of America. We'll begin with a programming note about something very special coming up in later this month and then also into March. February 25th, March 4th, and March 11th. All three dates, I know they're already on your calendars for Morning Cannolis. Our presentations those mornings, special presentations. It is approximately halfway through, believe it or not, the present term, the 2022-2023 term of the United States Supreme Court. We've seen that they've been active in October, November, December, January, and this month of February. As they head into the halfway mark of this term of the United States Supreme Court, we're going to pause in some of our up-to-date contemporary news analysis and go back to the Supreme Court and talk about the things that they have been engaged in these first 6 months. So sort of a check on where they have been, what they've been doing up to this point, and then also looking forward, of course, a short 4 months from now, probably May, June, arguably into July, announcements by the Supreme Court of some of their major decisions, many of which we have highlighted in the fall of last year. We visit some of those and talk then about predictions for the future. The three components of those upcoming broadcasts, those special recorded broadcasts on February 25th, March 4th, and 11th, three basic components. We're going to go back and do some basic civics work again, how the courts work, how they function, their operations, a little bit of structure, a little bit about the federal courts generally, because that is animated, I know, lots of the great questions that you have had, callers have called in to talk about. Second, we're going to talk about one or two, maybe even three cases in our contemporary experience here in America, things that have defined who we are as a nation, how we live, how we go about living our lives, two or three cases that continue to have an impact upon us every single day of our lives. And third, some major stories, again, news stories in the life of America, the lives of Supreme Court justices and their activity and their engagements having to do with ethics rules. We know that recently the Congress has introduced some legislation. We'll see how far it goes to establish specific rules on the behavior, the conduct of Supreme Court justices. We'll talk about that a bit. We know that this all happens in the wake of the release almost a year ago now of the Dobbs decision, ultimately decided in June of last year, overruling Roe versus Wade, establishing perhaps a new course of conduct in the area of privacy rights for America. And also we're going to talk about the demeanor, the conduct of justices sort of on the bench, but also importantly off the bench, which has also been the focus of a lot of reporting. The speeches that they give, the comments they make in interviews. So lots of contemporary stories about the Supreme Court, but again, focusing about halfway through their present term. Those broadcasts again coming up on February 25th, March 4th, and March 11th. Tune in for those, that special programming note this week. As we always do on Morning Cannolis, including this morning, February 11th, I'm going to spend a little bit of time in this first segment talking about today in history, things that happened in the history of our nation and our world on this day in history, February 11th. Let's begin way back in 1753 in our own nation. Believe it or not, it was on this day, February 11th, in 1753, the first organized, known, identified hospital that we'd identify as a hospital opened in Pennsylvania. Began admitting patients on this day, not surprisingly at all, co-founded by one of our founding fathers in our nation. His name, of course, Benjamin Franklin, thus the starting of that hospital in Pennsylvania, 1753. Let's jump way ahead to 1975. Again, another news item from our history in the general area of progress, movement forward in mankind for all of us. This was the day in 1975 that British politician, a woman named Margaret Thatcher was elected to the leadership of the Conservative Party in the United Kingdom. She was replacing Edward Heath, who had been the prime minister at that time, the head of that Conservative Party in Great Britain. And 4 years later, in 1979, Margaret Thatcher, as you all well know, would become the first woman prime minister, the first female prime minister on the European continent, that happening in 1979. But on this day, February 11th, 1975, she became the leader of the Conservative Party, again, anticipating her rise to power at the head of the UK government in 1979. 1990, more movement forward in America, movement forward around the world, including especially in South Africa. After serving 27 years, over a quarter century in prison, a man named Nelson Mandela. His name rings, of course, civil rights, human rights in all of our ears. Nelson Mandela was finally released by the apartheid government in South Africa on this day, February 11th, in 1990. It was after that release, and of course he became, not only during his time in prison, but even before that, certainly after that, a major rallying figure for the overthrow, the dismantling of apartheid in South Africa. And sure enough, pursuant to his commitments made in writing, made even orally while he was in prison there in South Africa, he began negotiations after his release, almost within the hours of his release on February 11th of 1990, with the president of South Africa. His name, you may recall, F.W. de Klerk, who again was the last major leader in South Africa, presiding over the horrific non-human rights, anti-civil rights policy and practice of apartheid, separating the races according to race in all things, including housing, including economics, including arts, including athletics, all the kinds of things, commerce, business, everything. Apartheid. Nelson Mandela, of course, as you all well know, would go on to be successful in overthrowing that and ultimately becoming the leader of the South African nation. But today, 27 years ago, he was released finally from prison after almost a quarter century in custody. And finally, also moving forward in the history of America, it was today, February 11th, that Egyptian President Hosni Mubarak stepped down after nearly 30 years in power, the head of the Egyptian government. You may recall that was following some mass demonstrations that were part of a pro-democracy uprising in Egypt, and then it spread to other nations in northern Africa, throughout the Middle East as well, known as the Arab Spring, that happening, of course, in 2011. As a result of those those nationwide protests, Hosni Mubarak stepping down after nearly 30 years in a position of power there in Egypt. As we know as well, the Arab Spring did not live up to all of its promise in terms of overthrowing the anti-democratic powers in Egypt and in other nations. That is a struggle still continuing to this day on February 11th, 2023. All those things, however, signs of movement forward, signs of progress in our national and our international history. We will look forward to more of that as we continue this morning and down the road in our discussion of the major stories in law, in government, and in the aspiration for justice in America. All those things happening on February 11th in years past. Another program note, another thing that we note happened just this past week. Program note and a passing, actually a passing of two people, one of them involving a point of personal preference that I'm going to be pursuing in the last segment of our second hour coming up in the 10 o'clock hour. This past Wednesday, two people died. One of them is named Burt Bacharach. And his name is Bill Hotz, whose name you may not recall, but I know, but I'm going to talk a lot about him in our final segment in the second hour this morning on Morning Cannolis. Let's talk right now a little bit about Burt Bacharach, who died this past Wednesday. He lived from May 12th of 1928 until February 8th of this year. All of you, I suspect, young and older, know well. Burt Bacharach, an American composer, a songwriter, a record producer, and a pianist as well. Widely regarded as one of the most important and influential figures of 20th century popular music. You may think, well, gee, what does that have to do with news about government and law and justice in America? In many ways, Burt Bacharach's music was the music of the 1950s, the 1960s, the 1970s, when, in fact, we did make some great progress in the area of civil rights and movement forward here in my lifetime, in the lifetime, I suspect, of many of you as well. And so we celebrate his life, composed hundreds of pop songs in the late 1950s, again, animated some of those movements, and animated some of those movements to this day, many of those in collaboration with a fellow named Hal David. His music characterized by those of you who are musicians, some chord progressions that were sort of atypical, influenced by jazz harmonies, received accolades, 3 Academy Awards, 6 Grammy Awards, an Emmy Award, 1961 to 1972. Many of Bacharach's and David's hits were written specifically for a great song stylist still with us named Dionne Warwick, and early associations with everybody from Perry Como and subsequent with people like Dusty Springfield and Jackie DeShannon, Bobby Gentry, Tom Jones, Herb Alpert, B.J. Thomas, the Carpenters, among many other artists known to us well. Gene McDaniels, Marty Robbins, Jerry Butler, also among those in the 1960s, the 1970s, the 1980s, and even the 1990s, continuing almost until the time of his death just this past Wednesday in our own history. And as we go out, we're going to talk more about Burt Bacharach and hear his music as well. That again, the music of Burt Bacharach, who passed away this past week after leaving a legacy of amazing music in my lifetime, in your lifetime, and animated much of the movements forward in the areas of civil rights and human rights in America, often the backdrop, the music of our times. Burt Bacharach celebrated this morning in our broadcast. We are here at the studios of WAUK Radio in the Shaw in downtown Waukesha, along with my terrific producer who is with me in those studios. We are taking your phone calls this hour and also next hour. That number is 844-967-2789, 844-967-2789. Calvin and I will be delighted to take your phone calls, to solicit, to obtain, to respond to your thoughts, your questions, and your inquiries about the major news stories we're going to talk about in this hour and next hour as well. So let's begin that ambitious but achievable, informative and inspiring syllabus, our agenda for this morning. We're going to begin in a federal district court in Texas, where we often talk about cases, many things coming out of Texas, as you well know. A Texas lawsuit, again, spent in the federal district court in Texas, brought by some conservative groups seeking to overturn a Food and Drug Administration approval of a drug called mifepristone in way back in 2000. Mifepristone, rather, is a widely used abortion drug. And this federal lawsuit, which is going to be decided, was assigned to the courtroom of a fellow named Matthew Kaczmarek. He is a federal district court judge in Texas. In the coming weeks, he promised a decision on it yesterday, but decided at the end of the court proceedings yesterday not to issue that decision because he wanted to involve others in offering suggestions, offering their insights into what he should do. The lawsuit itself, as I said, filed by some conservative groups, including a group called the Alliance Defending Freedom, generally known as a faith-based organization that has long sought to have abortion law outlawed nationwide, beginning way back in 1973 with the decision Roe versus Wade, a very active group around the country, including in the state of Texas. And again, focusing on this drug called mifepristone, if successful in this lawsuit, would attempt to ban that drug nationwide, even in states where abortion remains legal after the United States Supreme Court overturned Roe versus Wade just last June in this major landmark case that we have talked a lot about called Dobbs. Mifepristone, again, the FDA approved that way back in 2000, the year 2000, 23 years. It's often paired with another drug, which is called misoprostol. It's used to induce abortion without the need for a surgical procedure. This lawsuit, again, was filed by the Alliance Defending Freedom, along with about 4 doctors who have treated patients with the drug. Their argument in the midst of this federal lawsuit is that using mifepristone comes with some medical risks. And in particular, one of the attorneys for the Alliance Defending Freedom has said this. He said, "Our frontline doctors have firsthand experience in treating and caring for the women and girls," he said, "harmed by these drugs. We hope the court holds that the FDA should be accountable for recklessly approving these harmful drugs without following law and science." Now, needless to say, there is opposition to that view, not only by the defendants in this case, but also by many others. Thus, the judge soliciting more argument, more positions, statements of position by other people out there. And sure enough, one of those, the Vice President of the Planned Parenthood of America, has said this: "Mifepristone is safe, it's effective, and has been used by more than 5 million people since the FDA approved it more than 20 years ago." Goes on to say this case, again, this federal lawsuit pending in the federal district court in Texas, trying to stop the distribution, the FDA authorization of this abortion drug. This case is a politically motivated attack to remove mifepristone from the market, which could have far-reaching consequences for patients' access to abortion nationwide and to other FDA-approved medications. That, again, a statement by Planned Parenthood, not surprisingly, opposing this request to the federal court to stop the distribution of this abortion drug and effectively overturn a 23-year-old ruling found by the FDA after lots of examination of the effects of this drug. In 2020, about more than 50%, about 51% or so of abortions are induced using this medication, mifepristone, according to data from the Centers for Disease Control. Now, the lawsuit, of course, gives people a lot to talk about, not only in the wake of the overturning of Roe versus Wade way back in June of last year. It seems like a long time ago. It has only been, again, about 9 months or so since that happened. Obviously, the Supreme Court opening up the doors nationwide to further discussion and, importantly, legislation, some referendums around the country about whether or not, in particular states, the privacy right to abortion, long recognized for nearly 50 years, 49 years, should be acknowledged by the states. And therefore, today we have not only this emerging, but this present pattern of patchwork around the nation, places where you can, in fact, get an abortion legally, places where it is increasingly illegal to get an abortion. So the lawsuit, again, coming out of Texas, this gives people a lot of focus, not only in those other states, but in the state of Texas and throughout the United States of America, because of the possible impact of the decision by the judge, probably forthcoming in the next couple of weeks, finding whether or not the FDA approval of mifepristone was proper or not. The lawsuit, again, was very rare because it is rare that there's litigation against a federal agency for a decision made almost a quarter century ago. But significantly, this is not the first time that there's been a question about whether this drug, mifepristone, should have been approved. There have been investigations and documentation that the FDA has regulated the drug pretty closely, and that's a part of our record, presumably a part of the record as well. And so we're going to talk more about that particular case, the impact of it, what's going on, why it's important for you to know about that as we come back here right after this first break here in Morning Cannolis. This morning, we are talking the first of our major news stories pending in America. We're talking about this lawsuit that has been pending in a federal district court in Texas before a U.S. district judge whose name is Matthew Kacsmaryk. He is a judge who has previously issued opinions that have not been sympathetic to privacy rights and abortion rights. Right before the break, I was talking about the fact that this particular drug called mifepristone, has been the subject of an awful lot of review, an awful lot of examination throughout the last 22 or so years. Government Accountability Office, sometimes called the GAO, had a report some years ago, almost 60 pages in length, that went through everything that the FDA has done initially when it took a look at this drug initially, and then since that time. In fact, during the course of its review of the efficacy, the productiveness of this drug, it in fact turned down mifepristone's application twice before approving it. So this is not at all a story of hasty approval by the FDA of this abortion drug. It's a story just to the contrary of a pretty long process that was involved, had a lot of different moving pieces administratively, and certainly premised upon the medicine, the facts, the science, which is what we always should be focusing on when making these important decisions. So the idea, which is implicit in this lawsuit, that the FDA acted rashly and outside of its powers in weighing that evidence is simply belied by the evidence. And I think that the decision to file in this court, again, where Judge Kacsmaryk has in the past issued opinions that have been hostile to privacy rights, abortion rights in particular, this decision to file this lawsuit there is very purposeful. And again, the question is, if indeed in the next couple of weeks, which he probably will do, he issues an opinion on this, what is the impact of that here in Wisconsin and throughout our nation? Well, a lot of it depends upon what kind of injunction the court may enter. Of course, he's got the capacity not to enter any injunction at all. Predictable, given his history and given his focus on this lawsuit up to this point, that he will be doing something in this area. So if the judge issues a nationwide injunction, which again sounds stunning, I know, that a single federal judge in Texas, essentially the court would have ruled that mifepristone was not appropriately approved by the FDA and should be taken off the market. That's why this lawsuit is so very, very important. Again, as an outgrowth, plainly, of the decision in Dobbs of last June, in the wake of the overturning of Roe versus Wade, this tremendous affirmation back in 1973 of the privacy right, reproductive rights at the time. Now, the FDA, after such a decision, could reinstate it, do some administrative things to put this back on the market, but that would plainly require some time and some initiative, which the FDA plainly does have. In addition to that, while this case is being litigated, presumably also taken up on appeal, the FDA would also be doing other things to look at its authorities in this area, almost certainly depending upon what the lower court, the district court judge does in this case. There'll be an appeal. And where does that go? That goes to the Fifth Circuit Court of Appeals, because Texas is one of those three states in the Court of Appeals for the Fifth Circuit, also including, of course, Louisiana and Mississippi. That Fifth Circuit, as you well know from having been a part of this program on Saturday mornings and many others here on the broadcasts of civic media and in other media outlets, Fifth Circuit has its own track record for the decision-making that is not appropriately, not necessarily sympathetic to abortion rights. And although we don't know exactly what may happen before an appeals, a panel of that bench, the Fifth Circuit, highly likely that if Judge Kacsmaryk issues an injunction preventing the FDA from continuing to support the nationwide use of this drug, that the Fifth Circuit Court of Appeals would support that, perhaps ultimately headed to the United States Supreme Court. A significant decision pending right now, no decision yet made. Anticipate that sometime in the next 2, maybe 3, maybe 4 weeks or so, we're going to get a decision out of that district court affecting, once again, not only this fundamental access to reproductive rights, but also the manner in which abortion rights are implemented and observed in this nation, including right here in Wisconsin. That's the reason why it's important. That's the reason why we should all know about this, continuing to be vigilant, both here in Wisconsin and in other places with our elected, our appointed representatives, to ensure that this fundamental notion, privacy rights, as we talked before, not just in the area of reproductive rights, but certainly that has been at the top of the list, but in many, many other areas of our lives. And of course, we recall well that in the decision in Dobbs back in June, the Supreme Court said we're stopping here. We're not rolling back other privacy rights. One Supreme Court Justice, Clarence Thomas, plainly saying, well, we shouldn't do that. Let's relook at other areas, including the rights to marry, including the right to contraceptives, other areas like that, LGBTQIA rights. Likewise, he's suggesting that we revisit all of those issues when it comes to identifying a fundamental privacy right for all Americans. Plainly something that we should be advocating for locally, throughout our state systems, and also nationwide. That's what you do in the midst of these kinds of lawsuits around our nation. Let's return then to a common discussion that we have had, and that is matters related to January 6th and the insurrection at that time on our United States Capitol, the attempt to overthrow our government at that time. We know that there continue to be these prosecutions by the United States Department of Justice of thousands of people out there, some of them already convicted and sentenced to terms of imprisonment in excess of 10 years. We're going to talk about one of those in just a moment or so. Let's begin with one of those particular prosecutions coming out of that prosecution initiative, and that is that just this past week, in a federal district court, this one in the District of Columbia, a fellow named Kevin Seafried, who was 53 years old, was sentenced to 36 months in prison for his involvement in January 6th. And the reason for that significant decision this past week, the sentencing of him, is, you may recall that Seafried was among those who was found guilty way back in June of last year, entering a restricted building, namely the United States Capitol building, disorderly conduct, and also unlawful parading at that time. He brought his son along at the time, his son Hunter, also charged for partaking in the riot. He was sentenced to 2 years in prison last year. The Seafrieds had traveled to Washington, D.C., as had thousands of others, to attend then President Trump's Stop the Steal rally. We have talked about that a lot. Near the White House on the ellipse on January 6th, prosecutors in the context of these two Seafried cases had said that this particular defendant, Kevin Seafried, among the first protesters to breach the Capitol, to go into the building violently. He entered through a broken window and remained there for about 25 minutes or so. He was photographed a short time later in a fairly iconic picture that we've seen in the news, carrying a Confederate flag. According to the court documents, the positions articulated by the federal government in this matter, he said he brought the flag from his home in Delaware, where it usually hung outside. Again, this Confederate flag brought inside our nation's Capitol building, our place of tremendous importance historically, and the People's House, the place of legislation. According to testimony from a U.S. police officer, Eugene Goodman, who we've heard about in other settings, Seafried was among a group of rioters who asked him and yelled at Goodman and others, "Where are the members at?" And they then turned to Goodman saying, "What are you going to do, shoot us?" Goodman talked about his confrontation with Seafried at that time, described him probably diplomatically, probably a wild understatement, said that Seafried was the complete opposite of pleasant, and said that he had used the Confederate flag to jab him. That is, the police officer saying he was jabbed by the very Confederate flag that Seafried had brought in with him. And so prosecutors in this case alleged and proved, established by virtue of the conviction and now the sentencing, that Seyfried had thrust the butt of his flagpole at Officer Goodman, not only a weapon capable of causing some serious injury plainly, but also affixed to it, brandished by a man standing at the front of a very volatile, growing mob that was assembled there. So again, this past week, this fellow sentenced to 3 years, 36 months in prison, joins the ranks of now something in excess of 1,000 people, in addition to the others likewise responsible for the January 6th insurrection, the assault on our democracy. I'm going to take some phone calls right now about some of the things we've talked about this morning already, maybe other issues as well. Dick, you're calling in from Madison. Dick, appreciate your time this morning, your thought or your comment here on Morning Cannolis.
Hello?
Yes, Dick, we're ready for you and love to have you on
Oh, sorry.
the program here this morning. Absolutely. Go right ahead.
Sorry. To January 6th and Merrick Garland, you've heard me kind of rail on him from time to time, and I think he's moving way too slow. But one thing I will give him credit for is he's reestablished tremendous credibility in the department again, almost overly done when he's treatment of the former president. But I think what maybe he needs to understand, far be it for me to tell him this, but he's never going to make everyone happy. And he seems to want to do that. And being Attorney General of the country, I think you're going to make people unhappy no matter what the call is.
It comes with
but
the
at
job,
least
right?
make the call.
Absolutely.
Yeah. And I just don't understand. It seems to me that he thinks that he's going to make everyone happy. And he's not going to make anyone happy if he just sits on this completely on one side. And then on the other side, we know what could happen as well. But just to sit on it, I don't get it.
Right. And Dick, very, very good point to make. I was a prosecutor for about 30 years, including about 6.5 as the U.S. Attorney for Eastern Wisconsin, our easternmost part of our state. And on a regular basis, when we made decisions not only about who to prosecute, obviously through the grand jury, decisions made in trials, in pleas, in sentences, even on appeals to the Seventh Circuit Court of Appeals, on a routine basis, I and others, my colleagues in the U.S. Attorney's Office, my colleagues throughout the U.S. Department of Justice, routinely attacked, offered to also appropriately, right? That's the First Amendment. That's our freedom of speech in America to express our views. But that comes with the territory, as Dick, you're just saying, and that is a part of what happens whenever you make important decisions. I would offer, in addition, Dick, that what should guide this Attorney General, and I believe it does, I share your concern about some of the delay as we can begin to approach March 1 now of 2023. This is getting a bit late in terms of decision-making. Through the special counsel, Jack Smith and others. But the important focus of the Attorney General, of a Jack Smith, of all the members of the employment team of the Department of Justice, including federal agencies like the FBI and the DEA and ATF, all of it has to be on one thing, and that is service to America and the people like you, Dick, and others, and also the promotion of the rule of law. Those two things are the same. And if you keep your eyes always on what the facts can show and what they establish, in criminal cases, of course, beyond a reasonable doubt, what the law prescribes, what the law prohibits, and you join those two things together, you bring the facts to the law, and you make a decision not based upon partisan animus, partisan motivation at all, not politically, but based upon what that does, then in the end, you accomplish justice. Dick, very good point, well made. And this notion, once again, that in America, tough decisions also bring with them some public criticism. That also a part of who we are as our nation. Thanks so much for the call, the observation. We also have Jake on the line this morning, way from California, I think. Jake, glad to have you with us. Your comment or question?
Oh, I just want to comment on this part of the story that you read about the Confederate flag flying conservative traitor, okay, who said, "What are you going to do, shoot me?" Right. Talk about white privilege. I mean, we all know what would have happened on January 6th had the rioters been, a different color, or had they not been a bunch of pro-Trump, toothless, inbred hillbillies from the South carrying Confederate flags and swastika flags and urinating and defecating in the Capitol, destroying the Capitol, looking for our congressional leaders to kill, for the vice president of their own party to kill, to hang outside in gallows they constructed. We all know what would have happened if this had been a different kind of political group attacking the Capitol. They would have been machine gunned. Okay, there wouldn't have just been one person shot dead. We all know there would have been hundreds of people shot dead, especially if they were black rioters. We all know that's true.
And Jake,
So when this white,
go ahead.
when this white Confederate flag guy says, "What are you going to do? Shoot me?" Well, he's just telling you what we all know. In some respects, these right-wing radicals, these traitors, are basically above the law if they have enough money. If they're poor, they're going to go to prison. But if they're rich, I don't know if anything's going to happen to Donald Trump.
Right.
I'm still waiting.
Right. And Jake, the presence of the Confederate flag, among other things related to this story, especially problematic, right? As you say, bringing that symbol of racism into our nation's capital, in addition to the other comments you make, especially onerous and especially of concern. So we'll look forward to more of that kind of discussion right after this break here on Morning Canoe. And we are back this morning in this first hour talking a lot about the enforcement of law in America, the promotion of the rule of law. And again, I always appreciate our great callers calling in with insightful perspectives on those issues. Calvin and I, again, as we always do this morning, are taking your phone calls here at 844-967-2789. Let's talk more about January 6th right before the break, talking about this latest sentencing of one of the 1,000 of defendants who have been found guilty, a judge guilty, criminal judgments entered against them, felony prosecutions, misdemeanor prosecutions, and also, as we know well, two other major things going on. One of them, of course, these continuing trials of these mid-level, very, very concerning prosecutions of Proud Boys, Oath Keepers, 3%ers, responsible for summoning into Washington, D.C., organizing conspiracies to take over the nation, to overthrow our government, charged with seditious conspiracy, getting convictions, the Department of Justice is, against the leadership of those, even as those trials continue. And we also know that as a third tranche, a third component of the Department of Justice response to what happened on January 6th, the first portion, again, these thousands of on-the-ground people breaking in, committing crimes there in our nation's capital. The second group, once again, organizing seditiously this conspiracy to overthrow government. A third focus upon the highest level of management, of supervision, of conspiracy, to involve other people, to involve themselves in this attempt to overthrow our government, that being led by Jack Smith, who is the appointed special counsel through the Attorney General, Merrick Garland. We know he's also responsible for the Mar-a-Lago investigation. Footnote that right now. We're going to get back to that in just a moment or so. But we know some major news coming out of that component, this highest level of the investigation coming out of the news just this past week, and that involves our former vice president, whose name is Mike Pence. He has been subpoenaed by the special counsel, who again is investigating former President Trump's efforts to cling to office, to stay in office, to overthrow the results of the November election and remain in office after January 20th of 2021. After he lost that election in November, and again, Jack Smith, as a part of his very aggressive continuing oversight, his pursuit of matters related, the highest levels, if you will, of supervision, organization, control, direction, identifying plainly people who are responsible for making those decisions, including the former president, not exclusive to him, but including the former president, Donald Trump. So he is subpoenaed the vice president, arguably among the most significant stories of this past week. That is a subpoena to appear in front of, yes, that's right, a federal grand jury convened in Washington, D.C., right there along Pennsylvania Avenue in the federal courthouse there. Jack Smith plainly talking with a lot of people in front of the grand jury. This federal grand jury obviously collecting information. At some point, have to believe that there will be a presentation to this grand jury of some proposed indictments charging people with these high-level involvements in January 6th. Why is this an important story that Jack Smith has decided to bring in, to summon in before the grand jury to provide testimony from the former vice president? Well, first of all, it is significant because if you think about it, this individual, our former vice president Mike Pence, is probably one of the most important fact witnesses of all, right? We know from the past reporting, much of it verified by people in the public domain, that in the weeks, arguably the months ahead of January 6th, as Pence himself has said, he had many conversations with the president, the now former president, about whether or not he had the authority under the Constitution to overthrow, to overturn, to disregard the electoral votes presented by all the states to the Congress on January 6th. And he was in a dispute with President Trump about that. So lots of conversations. We know as well that there was a factual conversation, a very tumultuous conversation on the morning of January 6th before the Ellipse event itself, in which apparently the president called the vice president a wimp for his failure, his decision not to go ahead and not to try to disregard the proper electoral votes presented to him and then Speaker Nancy Pelosi. Lots of disagreements. So plainly lots of conversation, arguably even after January 6th. Why is that important? That's fact information, right? That's evidence of what the president said to him, what others may have said to him, and may also be in the focus of Jack Smith right now. All of that incredibly relevant information. And then, of course, the other reason why this fact information, this evidentiary basis that only Mike Pence can provide is also significant is that he was right there, right? He was in the Capitol building at the time of the insurrection. We saw those images as he and Nancy Pelosi and other members of the Congress were ushered out and brought into safe and secure areas. We know 5 people died that day as a result of this onslaught. Pence was there. Pence obviously having conversations. We know he was also engaged, unlike the president, in attempts to try to secure the Capitol and address this riot that was happening at the time. Plainly had conversations with many people in his own staff, some of whom have also testified before the grand jury, certainly others who have testified before the January 6th committee. So Pence has a lot of on-site specific information about what was going on, quite literally, moment to moment, minute to minute, with Nancy Pelosi, with others, with security forces, with his own staff on that day. And so, while this is incredibly important information, it is unlikely, highly unlikely, that Vice President Pence is on a list of targets or subjects of this investigation. He could be, but more importantly, probably more likely, he is on the list of fact witnesses. And for that reason, this subpoena to him to come in and testify before the fact-finding federal grand jury, and all-important part of this, one could make the very legitimate argument, I will make it right now, that Mike Pence is at the top of the list in terms of people to whom you want to speak in investigating what happened on January 6th, and especially with this focus related to the people most responsible for it. Now, we also know, of course, that the president, the former president, and his lawyers are probably going to raise issues of executive privilege. It is possible that Mike Pence himself, through his lawyers, may do the same thing. And again, as we have talked in the past, executive privilege has a place in American jurisprudence. It does not generally cover, shield, prevent the disclosure of information and evidence that is about a criminal enterprise. Executive privilege should shield discussions that involve things of national security, domestic policy, environment, commerce, taxation, all those, immigration, other things like that. If you're engaging in criminal conduct, traditionally not an appropriate subject of an executive privilege invocation, but probably some disputes about that coming up, maybe in the courts. Maybe Jack Smith is going to have to identify that and argue that in the court. We will continue to monitor this very important study of the grand jury and the subpoena issued in the times ahead. Stay with us for our second hour here this morning, February 11th, on Morning Cannolis.
It's the only thing that there's just too little of what the world needs now is love, sweet love.
No, not just for some, oh, but just for every.
And we are back for our second hour of Morning Cannolis. It is Saturday, February 11th, 2023. My name is Jim Santel. Thank you so much for joining me in this second hour of our program. This is, as always, our weekend review, our analysis, our discussion involving you too about the most important stories in the areas of law, in government, and the aspiration for justice in America. In this hour, as in our previous hour, we're taking your phone calls. Calvin and I, my producer, at 844-967-2789. Welcome your calls. Welcome your thoughts and perspectives as we pursue, once again, many of the important stories in law, government, and justice in America. Right before the top of the hour break, we were talking about the former Vice President, Mike Pence, and the fact that in connection with the January 6th investigation being led by the Department of Justice, by Special Counsel Jack Smith, that the former Vice President has gotten a subpoena to appear in front of that grand jury convened in Washington, D.C., to determine whether or not there should be charges against high-level people responsible for bringing folks to Washington, D.C., otherwise inciting the election, the overthrow of the election on that day, and furthermore, involved in matters related to a conspiracy to overthrow the results of the November election itself. And so all of that going on, obviously Mike Pence has an obligation to do what? He's got an obligation to show up, fundamentally. That's what you've got to do when you've got a subpoena issued by anyone in any court. We know well from previous prosecutions by the Department of Justice that people like Steve Bannon, Peter Navarro, others subject to criminal prosecution for their failure to show up in connection with congressional subpoenas. The same applies to grand jury subpoenas as well. And so Mike Pence almost certainly obliged at least to show up, determining whether or not his testimony will be the subject of litigation focusing on executive privilege. Already some signals by the former president that he, that is Donald Trump, may raise that issue going forward. And Mike Pence continues to be in the news in another area, and that is just this past week, in an unrelated, presumably unrelated matter, not involving January 6th, we know that the FBI conducted a consent search of the home of the former Vice President, Mike Pence, in Michigan. The former Vice President, and his aides had agreed to that search after they discovered a small number of classified documents there last month. And his advisor, his principal legal authority in this area, said this. He said, the Department of Justice completed a thorough and unrestricted search of 5 hours and removed one additional document with classified markings and 6 additional pages without such markings that were not discovered in the initial review by the Vice President's counsel. The Vice President, the spokesman went on to say, has directed his legal team to continue to cooperate with appropriate authorities and to be fully transparent through the conclusion of this matter. And again, this event, the discovery of this additional document, a part of a consent search, comes a day after these reports that Mr. Pence, the Vice President, had received a subpoena from the special counsel on this other matter involving Donald Trump's attempt to overthrow the 2020 election. And once again, why is this story important? Well, it's important to understand the difference between the reaction, the response by the former Vice President, that is Mike Pence, to cooperation and a consent search of his residence. And by the way, the Pences were not there at the time that the search took place. The difference between that, on the same side of the line, the consent searches permitted by the attorneys and by the representatives of our current president at his home in Rehoboth, in Delaware generally, and at his think tank office after he left the vice presidency. All of those locations also subject to the disclosure of information and documents and consent searches, cooperative searches, basically saying to the FBI, certainly after negotiation, after agreements, understandings about how these things will be done, but giving consent for the federal authorities to come in and do their own search. Witness the difference between that and what happened in connection with the Mar-a-Lago investigation that continues also to animate the news of this past week. In that situation, requests made, as we well know, months, arguably now well over a year ago, to produce documents believed to be in the possession of the former president, Donald Trump, a less than full disclosure of those documents, a grand jury subpoena issued by those, still not full disclosure, the issuance of a federally authorized search warrant in August of last year. a search warrant not on consent, but a result of a determination by a federal magistrate judge in South Florida that there was probable cause to believe that evidence of a crime existed at Mar-a-Lago. And so, again, witness the difference between the Pence-Biden response, consent searches happening at their homes and other locations, and the response to all of this investigation, again, by Jack Smith, unrelated to January 6th, related to the possession, perhaps the taking of documents that should not have been taken by these top-level officials in our government, present and past. Witness the difference between that and the response by President Trump that has indicated all along a less than cooperative attitude. And sure enough, this past week, once again in the news, because we got news just yesterday that there were new classified documents found at Trump's Mar-a-Lago residence in Florida. Lawyers for the former president turned over to the Department of Justice in January, a few weeks ago, additional, more classified documents, as well as, and listen to this, a laptop belonging to one of Trump's aides that were still apparently at the former president's Mar-a-Lago residence, even in the wake of the August 6th investigation and the search of those premises on that federal warrant. The discovery of this new package, if you will, of documents, which significantly also included an empty folder, again, this according to reporting, this empty folder labeled classified evening information. Classified evening information occurred in mid-January, as I indicated, when President Trump's legal team searched the home for yet additional confidential files that may still be there. Why is this story significant? Well, it indicates once again a lack of cooperation, presumably, in doing this much earlier. And second, arguably the most important reason why this story, again, producing not the great numbers of documents, but the fact that one of these classified documents, maybe more of them, were on this laptop belonging to one of his aides, handing over a binder with these classification markings about that document, other documents a few weeks ago, and also that at least one, if not more of those documents, electronically copied onto this laptop computer belonging to the aide of the former president. Again, why is that significant? It shows for the first time, in my assessment, that the former president, Donald Trump, and his staff are actually doing something with these documents. The great question back in August and continuing to this day, frankly, the question one can legitimately ask about Vice President Biden, about Vice President Pence, and also President Biden, is what were you doing with those documents? Every indication from the cooperative nature of their response that those two were not doing anything with them. They were simply sitting in boxes at homes in this office with respect to the current president in Washington, D.C. Nothing going on with them, not being used for any particular purpose. Here, we have got the first indication that indeed the documents in Mar-a-Lago were being used for some purpose. How do we know that? Transferred in some way, copied electronically into the laptop computer of one of his aides. The question, once again, why are you doing that? What are you doing with that presumably piece of classified information so important, so significant that it ends up into the electronic laptop computer of this aide? Raises for the first time the notion that indeed these were not simply inadvertently there, sitting there without any activity, but actively being used in some purpose. That should provide an awful lot of concern among all Americans and further indicates something about intent, which we have talked about a lot before when it comes to the possession and the use of these documents. A lot going on, again, in connection with not only our former Vice President Pence, but also our present president and the former president, Donald Trump. Let's take some additional callers here on Morning Cannolis. Joe from Madison, you're calling in. Thanks, as always, for your thoughts, your good comments and perspectives, Joe.
Great information as always, Jim. I really appreciate it. I wanted to just take one step back on the subject of Mr. Pence and his coming in to discuss what he knows with the prosecutors. My question, I'd like two parts to this. First off, I'd been under the impression with some reading that there'd been a great deal of negotiation between Pence's lawyers and the prosecutor in terms of getting him in to testify as a fact witness. As somebody who's done this kind of work, does this usually involve that level of negotiation? Is it to ensure that he's not spilling state secrets that he shouldn't? Or, I mean, I just imagine if I got a subpoena, it would be show up here this day. There wouldn't be a lot of negotiation about what I could or couldn't. So I'd be interested in your speculation on that, why it took so long to make this happen. And then I'd also be interested in your speculation. Another lawyer had said that the fact that Mr. Pence has been chosen to come in to testify, to him signified that things are really beginning to race up and that we should expect to see things barreling along. He described it as it's the car chase section in an action film. My question would be, why would that be true if it takes so much effort to get, and time and negotiation to get somebody like the vice president, who after all is a government servant, you know, he's paid for with taxpayer dollars, to agree to come in to talk to the prosecutor? Why would that not indicate that there's going to be just as much negotiation on anybody else that's called in? I'd be curious about your speculation on these 2 points. Thank you very much, Jim. Really appreciate it.
Absolutely. And Joe, as always, terrific questions about how this works, sort of behind the scenes, right? And it's not unusual to begin to offer some thoughts in response to Joe's excellent questions to talk about how this works. I think the first and most important thing, Joe, is the comment you just made at the end, which is it's the lesson of civics from this program and others. When you get a subpoena, what do you have to do? You have to show up. That's first and foremost. And so that is a fundamental notion. That's why I think most people believe that the vice president will indeed be obliged to show up. Right after the break, I'm going to talk more in response to Joe's questions. Great questions about the negotiation leading up to that and why that is important. Stay with us for more of that discussion here on Morning Cannolis.
Why don't you answer my prayer? You know, every day I say a little prayer. I say a little prayer.
Welcome back to our continuing discussion about major stories in law, in government, and the aspiration for justice in America. Right before the break, Joe had called in with some great questions about what happens in connection with this negotiation process that we've heard a lot about in connection with the former vice president's plans, presumably plans, to appear in front of the federal grand jury in Washington, D.C., under the auspices, again, of the courts, but supervised by Jack Smith, the special counsel investigating January 6th generally. Joe had some great questions about whether or not this is routine, what kinds of things typically happen, and how do prosecutors go about dealing with these things, and why is it, I think implicit if not explicit in Joe's question, that a vice president should be afforded this opportunity to negotiate his, perhaps with others, her circumstances of appearing. All great thoughts and great questions. Again, the fundamental notion, you get a subpoena, you are obliged to respond in some way. Now, one of the responses, of course, could be to run into court and seek to have that quashed, basically having a judge find that it's maybe improperly been issued. Highly, highly unusual, highly, highly irregular. We're not talking about a trial here. We're talking about investigation. And there can also be limitations, if you will, on the circumstances, the kinds of things that a witness appearing before the grand jury can testify about. We mentioned executive privilege as one of them. Very limited in this particular circumstance because, again, you're not talking about major issues, but arguably could be the subject, likewise, of a presentation to a federal judge, someone contesting this. But the issue about negotiation, does that happen? The answer is yes. The answer is yes. It's not unusual for a defense counsel representing a defendant summoned, subpoenaed to appear before a federal grand jury to call up an assistant U.S. attorney like me, like others, call up a U.S. attorney and say, you know what? We understand our obligation to respond. We would like to talk with you, number one, perhaps about the timing of it. We don't know exactly when Vice President Pence is scheduled to come in, but more importantly, want to talk with you about whether or not we can provide that information, for example, in a non-grand jury posture. That's a possibility in the discretion of the prosecutor. We want to talk with you about some other things related to that. Privileges we may raise, depending upon attorney-client privilege or a medical privilege, a health provider privilege, those kinds of things. I want to talk generally about information, cooperation, if you will, along the way. Not unusual. Doesn't happen in all circumstances. Often witnesses will simply show up on the day and the time of their appointed appearance and appear before the grand jury, questioned by the assistant U.S. attorney, by the federal prosecutor. But it does indeed happen. It doesn't happen in all cases, but it's not atypical, and it could be a part of the process. In the end, understanding, however, as Joe's comment and question underscores, this is a grand jury subpoena. It's not really a matter for negotiation about whether or not compliance should happen, but if indeed there are ways in which the government, the prosecutors, can in fact get the information in a way that also satisfies some interest, not nearly as compelling as the government's, that can be negotiated. It should not, to Joe's good point, take up a huge amount of time. And if indeed there is negotiation that is obviously intended to delay the proceedings, prosecutors like me, like others, will say, you know what, we're no longer going to pursue this. Just show up on that day and we'll talk to you in the grand jury. The vice president, the former president, others involved in this process, others involved in grand juries throughout this country, 93 different districts, every single week. People testifying before grand juries, all of them are responsible to do what? To show up. They are sworn, and they are responsible for testifying. Why? Because no one is above the law. We know that from things like the Mueller report. We know that from cases that are issued by federal district court judges and appellate court judges all the time. Everyone, whether you're the vice president, a former president, whether you are the president of the United States of America sitting in the White House at the time, you are obliged to abide by the rule of law. We know that because that is the foundation upon which our nation is premised. And so we hope that the investigation here continues with the cooperation of the vice president, although we're going to hear an awful lot more about that because of who he is and the fact that his testimony, as I said, incredibly important, incredibly fact-based, obviously has to be at the top of Jack Smith's list, is important. This other comment about the fact that this may in fact be leading toward a return of an indictment or indictments, probably so. The notion that maybe you don't call in the vice president until you're pretty much sure what all the others have said around him. At the same time, again, difficult to believe that the former vice president is a target or even a subject of the investigation, given his involvement in pushing back against Donald Trump. Unlikely that he will be charged with anything here, more likely a fact witness, but nonetheless, someone you would talk to perhaps near the end of your grand jury or general investigation, anticipating, as we have talked before, that there will in fact be some indictments coming soon. The focus of Joe's call, other callers, time is of the essence. And yes, indeed, Americans, including me and others, getting increasingly concerned about the passage of time absent any returns of federal grand jury indictments, state indictments as well, related to these events. Greg from Madison also on our lines this morning. Greg, glad to have you with us. Your comment, question, or perspective?
Yeah, I had two questions. I've heard this referred to by some Republicans as raid, and I was just wondering if you could tell me the difference between what a raid is and what happened at Mar-a-Lago. I heard it have to have a court order, I believe. But how did they know that the documents were there? Sure. Was there somebody from on the inside? Asked question number two. Was there somebody would they have to have somebody on the inside that knew what was going on to get this court order?
Great. Absolutely. Greg, terrific related questions, and so pleased to revisit some of these issues. let me begin with this fundamental notion about how it is you get a grand jury, a search warrant to pursue a search of the sort that we saw in August. We're going to talk about that right after the break. Do a little bit more civics here on Morning Cannolis. Respond to Greg's great questions about language and also process. So stay with us for that continuing discussion right after this break. And we are back for our final half hour here on February 11th of 2023. Morning Cannolis talking about issues related to government, law, and justice in America. Right before the break, a phone call from Greg, who had some great questions about language and also about process, and said, what do we know about this notion that there's an allegation that the Mar-a-Lago event was a raid on that property? How do we know that there was a proper government involvement in that search at the time? Great questions, Greg. Let's go back and do some basic civics on just that issue. Under the Fourth Amendment, as we know well, in our Constitution, since the first Congress of our nation, the Fourth Amendment basically says that every single American has a right to be free from unreasonable searches and seizures established by our founding fathers. And what that means is, before any government official, any federal official, and yes, it applies to the state as well through state provisions of the same nature. Before you can go in and search a premises, you have to have what's called probable cause to believe that there is evidence of criminal activity, of a crime, either being committed or having been committed inside that property. And so, Greg, to answer the first portion of your question, this notion that I can simply raid a place by getting up in the morning, whether I'm in law enforcement or even some private citizen, and make the decision that I'm going to bust down a door of a residence, of a business, is simply ridiculous. And the reason why people talk about this being a raid is obvious, right? It is to suggest that indeed the proper process under the Constitution was not followed, and that you did just simply have the government unilaterally violating the Fourth Amendment rights of individuals on the other side of that door. That does not happen. Or if it does, in those rare instances, those officials, those government agents who conducted a raid, absent a search warrant, or, as we've learned recently in connection with the current president and former vice president, absent getting consent to come in, which is the other way of doing this. If you simply raid a place, go in and knock down a door, you have violated the Constitution, and you are subject to civil lawsuit for violation of those criminal rights and constitutional rights under our nation's fundamental principles. So I would offer that there's no such thing as a raid in proper procedure. That is an attempt to try to induce all of us to think that indeed the government's done something wrong. It did not in connection with the search, the proper search under the Fourth Amendment of the Mar-a-Lago premises. And what happened there? Greg, as you asked most appropriately, what happened, of course, is that the government, the Department of Justice, presented to a federal magistrate judge, an appointed judge in South Florida, with about 30, almost 40 pages of information to establish probable cause. And Greg, you asked about, is somebody on the inside there who provided that? And the answer is almost certainly yes. I'd even say yes without the almost certainly. Why? Because we know that in order to establish probable cause, you have to have somebody who says what? Who says, you know what, I've been there. I've seen in a desk, I've seen in a drawer, I've seen in a closet, I've seen in an office some documents, I've looked at them, I know that they're there, I've seen them recently. It's a very important part of any search warrant that there be recency. That is, I can't simply come in 6 months later and say there's evidence of a crime in this particular house or this particular business, because the judge will look at me, will look at the investigative agents and say, well, how do you know that they're there now? How do you know that if we go in, I authorize you to go in tomorrow morning, you will find them today? That's also a part of probable cause. You also have to be specific about place. Where are you going? It can't just be a general search the area. You've got to have that inside person to come forward and say, I saw them in this office. I didn't see them in a residential area. I saw them in a garage. I didn't see them in a car. And so investigative presentations to a federal district court judge, or in this case, magistrate judge, are also always premised upon that kind of particularity, that specificity that ensures, number one, that the Fourth Amendment is followed, that you don't simply have a raid where people go in and kick doors down without authority. And how do we know that in this situation? Well, we know that because we've gotten a copy of the much redacted supporting document, the affidavit presented by the to the federal magistrate judge by the federal investigator that showed all of that information. Do we know who said what? Do we have the identities of those people and specifically what they said about where they saw documents and the documents themselves? The answer is no, because all of that has been redacted in the release of that document way back in the fall of last year. At some point, whether the case is indicted and goes to trial or that document is otherwise released in the context of a pretrial hearing, pretrial proceedings about the propriety of that search, we may, in fact, know more about that affidavit. But what we do know is that there were 30-some pages of information supporting probable cause, not a raid, a probable cause premise to go in and authorize, through that magistrate judge, the official search of that property. You didn't need to do that with respect to President Biden, the location in Washington, D.C., the two homes in Delaware. You didn't need to do that with respect to the home of the former Vice President Pence. Why? Because they consented to have those searches done. They're cooperating. In the other instance, you've got this non-raid, Fourth Amendment, properly executed search warrant in Mar-a-Lago. Very important. Good questions, Greg. Again, an opportunity to engage in some civics lessons here on Morning Cannoli. So thank you for that question, those observations about the way in which we use language in America. Not a raid, a search warrant properly issued and properly executed by federal agents responsible for following exactly what a federal judge told them to do. Let's talk about some other things going on in America, also in connection with federal enforcement of the law. We know in recent times that there has been this trend, not unknown in the past history of America, of people attacking power grids, principally in the northwest of our nation and now also on the East Coast in Maryland of our nation. An attempt plainly to bring power down to affect the operation of our nation. And so we know that just this past week, that a fellow named Brandon Clint Russell, he's 27 years old, comes from Orlando, Florida. Another woman named Sarah Beth Daniel, 34, of Cantonsville, Maryland, were charged with conspiracy to do what? To attack one of these power grids in Maryland, to destroy an energy facility, according to the release of the indictment against them that was announced by the U.S. Attorney in Maryland. Each of them for the attack on this power grid in Maryland could face a maximum sentence of up to 20 years behind bars in federal prison if convicted on that charge alone. So what do we know? What do we know about those folks, again, engaging in this not unknown, very troubling, very concerning practice growing across America once again to attack our power grids as a way of undermining our nation? Well, related to these new charges that were announced just on Monday, Russell accused of, again, conspiring to carry out attacks against this critical infrastructure of our nation, specifically this electrical substation, in furtherance of his, and this is from the charging document itself, racially or ethnically motivated violent extremist beliefs since at least June of 2022 to the president. The allegations in particular against Russell are that he encouraged, yes, once again, balloons in our news, encouraged the use of Mylar balloons to short out a power transformer. And in a conversation that the investigators retrieved way back from October 25th of last year, of 2022, Russell encouraged that the attack be carried out, quote, when there is greatest strain on the grid. For example, when everyone is using electricity to either heat or cool their homes. These are things that Russell said, now a part of the investigation. Why is that important? Because it establishes his intent to do this, not simply somehow a negligent interference with our power grid, but an intentional, purposeful, criminal intent to bring it down at the time of highest use, and also, again, tying him to these violent extremist beliefs that are also a part of his social media presentation. In conversations on encrypted communications applications, Russell posted links, some open source maps of the infrastructure, things you can get out there. Those included some locations of these electrical substations, indicating exactly where he was going to do this, how he was going to do it. And he described, believe it or not, a small number of attacks on substations, how those could cause what he called a cascading failure to support power in our nation, specifically in Maryland. And again, discussed maximizing the impact of that planned attack by hitting multiple serial substations all at one time. Now, the other defendant, Clen Daniel, who is again a woman in Maryland, allegedly collaborated with him on this plan, discussed her desire for this attack in some conversations, also now a part of the investigation. She allegedly stated that if they hit 5 electrical substations all in the same day in the Baltimore, Maryland area, again, these things coming from her own voice, her own words, they would, as she said, completely destroy this whole city, again, showing her intent to undermine the safety and security, the livelihood of that part of our nation. Went on to say, and that would happen for a good 4 or 5 shots through the center of them, meaning her attacks upon these power stations, and that should make that happen. That is to bring down the electrical grid and stop power from being disseminated to the populations in that area. She further added, it would probably permanently, completely lay this city to waste if we could do that successfully. All of that, again, according to the complaint against her and her co-defendant, Russell, in this major prosecution. Why is this happening? It's being pursued and produced by the government publicly to let other people know out there who might consider doing the same thing that not only will you be stopped, and again, an important thing about this particular event is it did not happen. Why? Because good law enforcement identified this, saw this happening on social media, saw these encrypted messages and arrested them, brought them into the criminal justice system before they could do what they planned to do. But again, deterrence, the all-important issue here, right? Alleging in this complaint that we know what these folks did, we know what they were planning to do, and as a result of this, we are seeking, and we have gotten, based again upon probable cause to believe that you have committed a crime. We talk a lot about deterrence on this broadcast. Once again, why is this important? Why is it important to know about this? Because it does stop these particular individuals, these two who not only had some incredibly inappropriate, violent biases, as I indicated, some ethnically, racially motivated communications, purposes that are also implicit in this prosecution, to stop them in particular. That is called specific deterrence, specifically stopping them from doing what they plan to do, identifying both of them and bringing them into the criminal justice system. Secondarily, having this broader impact upon the larger community. As I said, this is not the first time we have seen this before. We've seen this in the northwestern portion of our nation as well. If there are other people out there who are thinking of committing this kind of activity, engaging in this conduct that plainly is intended to stop the operation of not only government, but more importantly, arguably, the basic operation of who we are, how we live, how we conduct our lives, raise our families, educators, commercial entrepreneurs, business, commerce, arts, sports, all those kinds of things that rely profoundly upon power. If you're going to do that, we will probably be on top of you. We will identify who you are, and we will stop you not only before you will do that, but we will charge you in federal district court, arguably also in state court. There are also state violations plainly that can be charged here as well. We'll stop you from doing just that. So specific deterrence as to them, and also specific deterrence general deterrence as to others who might also be out there thinking about this crime. As an important footnote, Brandon Clint Russell had a former roommate a number of years ago who murdered 2 other roommates following a dispute on a conversion to the religion of Islam. Again, a whole lot more detail coming out of that. But this is a fellow who is not unknown to racism, not unknown to anti-Islamic positions, and so appropriately today in federal custody for his attempt to attack America. We're going to continue with another important part of our program this morning as we memorialize another person who left us just this past week. Stay with us for that discussion. Personal point of privilege here on Morning Cannolis. This is our final segment this morning on Morning Cannolis on February 11th of 2023. That music you're hearing right now, the music of Burt Bacharach, left us this past week. He died at the age of 94. This lion in the area of music who animated us, who instructed our lives through lyrics and music, stays with us, a continuing legacy. In these last moments, I want to talk with you, a point of personal privilege, about another individual who may not have animated us through music, but through both his presence, his activity, his professionalism, and his humanity, has been an important part of our community in Waukesha, in the state of Wisconsin, and I would offer throughout the United States of America. This past week, on the same day that Burt Bacharach died, a fellow named Bill Hotz, William Hotz, H-O-T-Z, also departed our company on this planet. But he stays with us, and his legacy continues. I want to tell you a little bit about him. He's a friend, he's a partner, and he is an important part of our continuing focus on what America should be all about. Bill was a graduate of the University of Wisconsin-Milwaukee, and yes, also a lawyer. The University of Wisconsin-Madison Law School, graduated with honors many years ago. A long and professional career in banking, accomplished, greatly respected by his peers, by those with whom he had adversarial relationships in the courts and beyond, in banking in particular. A tremendous attorney representing clients well, thoughtfully. We talk a lot about the rule of law in this program. Bill was the rule of law when it comes to all the things that he did in his service as a lawyer, and did things based upon a pursuit of justice. He worked for a couple of years in the Capitol, the Madison Capitol, our state capitol, in the Legislative Reference Bureau, and that also underscores Bill's concept of service to his nation and to his state. The Legislative Reference Bureau, of course, these folks, these lawyers, who are the ones who actually write the laws upon the direction of our legislators, an incredibly important work. Bill, again, distinguished himself in that area and in many other areas. We could go on and talk at great length about his legal career, stunningly wonderful and important in legacy to this day. I also want to focus upon the fact that Bill and his equally spectacular spouse, her name is Susan, she's a businesswoman in her own right, also very established in this area, also a part of our area focus upon the rule of law and promoting decency and common good in the state. Indeed, Bill and Susan, many years, longtime members of Common Cause Wisconsin, members, donors also. Bill was on the board of directors of Common Cause Wisconsin, among other things, as a part of his advocacy for rightness, for goodness, for things that should be a part of our state and our nation. Bill actually was in the United States Capitol, the Madison Capitol, also in the United States Capitol in his past, but specifically in Madison at the Capitol on many occasions. Among those recently, testifying against legislation that many of you will recall well that destroyed the nonpartisan Government Accountability Board. Bill, a great advocate, along with Susan and others, opposing that legislation. Also opposing legislation that destroyed basically Wisconsin's campaign finance laws, saying that there's a reason for those laws to ensure integrity in our political system and ensuring that people who are elected are not there simply because of money, but are following the rules to get your votes legitimately. He also was an advocate against a measure to exempt politicians from prosecution under the state's John Doe laws. All these pieces of legislation introduced a number of years ago in an attempt to undermine the rule of law. Who was there to stop it, to try to stop this activity? His name is Bill Hotz, and he was there as an advocate for you, for me, and for people who believe in the rule of law and things right and current. Bill and Susan, the entire Hotz family, including their daughter, Jessica, also an educator. Bill and Susan, great educators, people, academics who wanted us to know about things going on, invested in their daughter, Jessica, also a school teacher and educator here in the state of Wisconsin. Big education focus in their lives and big focus upon, yes, also partisan politics and supporting those candidates who advance the things that are good and right in America, focusing upon education, on healthcare, on commerce, on the arts, on immigration, on things that are important to all of us, especially in the areas of voting rights and elections that we have talked a lot about. That was and that is Bill Hotz. We remember him today. As we think about him and knowing that I was going to be talking about my good friend and continuing partner, Bill Hotz, many people wrote to me about Bill, commented to me about things like his respectful nature, his diplomatic demeanor, his intelligence, his informed approach to everything that he did. One of my friends said he was always precise, incredibly well-informed, not only in those public demonstrations of who he was and what he meant when he talked about advocacy for America, but also in private discussions, respectful, diplomatic, even being articulate and being clear, and even strident from time to time, appropriately so, in advocating for what he thought was right. Articulate and persuasive, the words used. One of the fellows who was from Common Cause, actually the director of Common Cause, some of the leadership there said he was one of the most nice, kind, generous, and caring people you could possibly imagine. Indeed, everyone who knew Bill during the course of his important life that continues to this day know that about Bill. We remember him today. Let me talk again and quote to you exactly something that one of Bill's colleagues and friends here in Waukesha in the state of Wisconsin wrote about Bill Hotz, who died again this past Wednesday. His legacy continues. What Jeff said about Bill was just this. What I remember most about Bill Hotz was his quiet yet determined demeanor, his steadfast commitment to democracy and the rule of law. Isn't that right? Bill was that special, kind, patient, focused, and methodical soul, Jeff wrote, who could calmly endure 142 interruptions in the course of a political conversation, and then, when finally given his chance to speak, would always make the very best points among everybody gathered here during the course of that conversation. All of those things from Jeff, from others throughout the community, celebrating the life of Bill Hotz, brought to an end just temporally, just physically on this earth, but again, a life that continues to animate all of us in not only the expressions that he articulated, the time that he had with us, but his legacy continues. We are all better for Bill Hotz, for that life. We are diminished in his absence only slightly because, as I said, his legacy remains with us now and always. Godspeed, Bill, as you go about the next portion of your life and your livelihood with us as a sign of what can and should be America in the 21st century. And with that, I thank you all for joining me this morning on Morning Cannolis. Join me again next week for more of our discussion about life, livelihood, for law, government, and justice in America. Have a good week, everybody. Take care.